by the European Court of Justice, saying you can't simply have mass retention of data, and they are given 9 principles or 9 safeguards, which we'll all place before the Supreme Court now. So the right to privacy in a digital age, as Justice Kaul points out, we are in a situation where the internet, the information technology is all pervasive and leaves a huge amount of digital footprints. Chandrachud puts it very good. He said this is recombinant because he says in digital data, the output can become the input from further output. So it can go on multiplying endlessly. So where do you draw the line? What are the security concerns? What are the things? As I speak, they have constituted Justice Sri Krishna Committee. And now I'll also mention 2 concerns which are pending before the Supreme Court. One is Aadhaar. The Aadhaar point is, it is a state-forced program. So privacy vis-a-vis a state actor. And the other issue, which is the Facebook and WhatsApp issue, privacy of non-state actors. Now, in the Facebook WhatsApp situation, what is happening is WhatsApp shares 4 pieces of data with Facebook. 2 petitioners, 2 students of eminent lawyers have filed a PIL in the Delhi High Court. Delhi High Court rejected it. It's come to Supreme Court. Now the Supreme Court is saying, what about privacy by non-state actors? They now say that Facebook and WhatsApp are like quasi-monopolies. You can't do without Facebook, you can't do without WhatsApp. I don't agree. I don't have Facebook. I don't have Twitter, but I'm very happy surviving. But then the point is, 99% of people have Facebook. It's a social networking site. You have a business networking site. The argument for WhatsApp and Facebook, they say WhatsApp is a messaging service. In WhatsApp, mind you, the message is encrypted. Even in the London terrorism, they refused, they said we are not able to give you what happens between the calls. So every WhatsApp call, every WhatsApp letter is completely encrypted, end-to-end encryption. It cannot be revealed to anybody. So WhatsApp says it's the most safe messaging service. Now Facebook. Now the proposal is, the submission to the Supreme Court is, we get large amount of data. What do we use it for? Facebook is free, WhatsApp is free, other sites are free, but how do these sites sustain themselves? There must be a commercial backbone to sustain this kind of manpower and things. So they say that we use it for targeted advertising, and the question arises, what is your right to privacy in such a situation? There the argument is, which has been a very good observation of Rohinton Nariman in that, he says, whatever you choose to put in the public domain is not covered by the right to privacy. You have to use it with a slight amount of caution. Now say for example, if I go to Google, and today suppose you go to Google and say I want to see, say for example, resorts in Jaipur. Tomorrow you will get on your, when you pop up, you will get hotels in Jaipur, flights to Jaipur and so on. So this is called, what is called targeted advertising. There are tools which say that, there will be a contract with Make My Trip or some Taj hotels that if anybody is asking for Rajasthan, put our ad on the thing. Now, is there a violation of right to privacy? The fact that I want to go to Jaipur, the argument is, in all these matters with non-state actors, privacy should be governed entirely by contracts. And that's why if you see Facebook, they'll say agree. Then after 15 days, they say, I still agree. And after 30 days, you have to say agree 3 times and say so. And there's a Lord Denning judgment saying if you give me a 100-word document and say agree, doesn't mean anything. So now, I think WhatsApp and Facebook, they give you the 14, 15 salient points which you must agree. So now it's left to the audience to see. I personally feel that as far as the non-state actors are concerned, it's a matter of contract. It's a matter of consensus. As long as they tell you up front what they're going to do with it, it's perfectly fine. I look at it this way. Everything you part with, you get a benefit. I want an insurance policy of say 50 lakhs. I have to go for a complete medical examination. My medical records are with the insurance company. But that doesn't mean they can use it further. They have to stop with that. If I want a 1 lakh policy, I don't need any report at all. I can just go for an ordinary policy. So everything has got a give and take. When I part with it by contract, then I can't complain about lack of privacy. At least as of now, Justice Nariman's judgment makes it very clear. What you have voluntarily parted with will not be covered by the right to privacy. Take an autobiography. I can choose It's part of my decisional autonomy. I can have a tell-all autobiography or I can have a limited autobiography. Both are entirely within my domain. So I'll conclude my talk by saying we are at the cusp of a very, very international, very, very landmark event, because there is, Justice Kaul has flagged the concern of Big Brother, Orwell's Big Brother, with so much of Aadhaar. You see, the whole difficulty with Aadhaar is, if it's seeded with every bank account, seeded with every phone, every school admission. I got a letter from Roorkee. The guy could not get his MTech thesis admitted because he didn't have an Aadhaar card. So I'm just saying that it is across the board, everything you will have to get an Aadhaar card. And there was a cartoon in the Times of India. A man is about to be hanged and the person comes in and says, stop, he doesn't have Aadhaar. So that was the extent of the Aadhaar. So now let us see what ultimately the Supreme Court says. And the topic is right to privacy in a digital age. My personal belief is, at the end of the day, whichever age we live in, the right of privacy, like the right to life, the right to be let alone, will always be present. And as Lord Brandis put it beautifully, he's saying at the end of the day, the most precious right, the most sacred space is the right of an individual to be